As solicitors, a lot of you are, I would imagine, from time to time engaged in sex cases. I know that the trial division of the county court is inundated with them. There's far more sexually related cases now being heard than ever before. Some may say, and I'm one of them, that that's probably as a result of a policy decision by the DPP, but that topic's for another day. The cross-examination of complainants as to character has always been a vexed issue, and legislation has for some time been in the old Evidence Act, which is now called the Evidence Miscellaneous Provisions Act, prior to the new Evidence Act 2008 coming into force, as it did on the 1st of January of this year, as it the same as the Criminal Procedure Act. The obtaining of leave to cross-examine complainants has always been a complex issue, and it relates to both cross-examination in the Magistrates' Court, in cases at first instance down there, right through the trial procedures in the County Court, and occasionally, if you ever get a sex case, being heard there in the Supreme Court. The topic for discussion now is in relation to that very issue. Our next speaker is Rodney Hepburn, and although Rodney has only been at the bar since last year, he has a wealth of knowledge in the criminal law, both as a solicitor and as a university lecturer. And I invite Rodney to now address you in relation to the issue of the examination, cross-examination of complainants in sex cases. Thank you, Rodney.
Thank you. I won't take you very long, but as Stephen says, it's a growing jurisdiction for many solicitors, and at the last statistical count, between 25 and 30% of all the cases and matters going through the county court are sexual offence cases, and that is the same statistic in the District Court of New South Wales and the courts in Queensland. But there has been quite a lot of changes since 2006, and what I've done in my paper is give you some sort of background to outline exactly the work that solicitors need to do to prepare for sexual matters, whereas it used to be quite easy under the common law. The sexual offence provisions in the old Act, the Evidence Act, came under Section 37, and that was changed in 2006. It was left out of the new Evidence Act for reasons that I still can't gather, but it's found its way into the Criminal Procedure Act, and you'll find those starting at Section, well, Division 2, the whole of Division 2 you'll find relates to the sexual offence cases. In page 2 of my my paper, just so that you can follow the changes in full. Those were the changes that the Australian Law Reform Commission recommended in 2006, and they have since changed quite substantially in the new provisions. And it's those provisions I wish to take you through. I've also attached to the back of the paper the old Act of 37A, so you can see the difference between the two provisions, and I'll discuss some cases in which might be beneficial going forward this year and into the future. So let's start with some of the new provisions. Section 340 defines for the first time what is sexual history evidence, and what is quite considerable is that for the first time they link sexual history evidence with sexual activity. In the old Act, they only mentioned sexual activity. Now they're linking sexual history evidence with sexual activity. Now before, in most of the cases, sexual history was that of the complainant, whether she was a prostitute or whether she was loose with her chastity. Now they are linking sexual history to include sexual activity, and that sexual activity may or not be ways in which the sexual intercourse or sexual penetration took place. And that may or may not be significant in regard the cross-examination of the complainant. Section 342, and just so that we can follow everything correctly, I've put under each section the old section. Some of the wording has changed, some of the wording has stayed the same, but just so that you can link in between the two. So section 342 used to be section 37A, 2A and B. And then section 342 we'll come back and talk about in relation to the without leave, because that hasn't changed. You can still cross-examine as to sexual activities other than those to which the charge relates without the leave of the court, and we'll come back and talk about that in a minute. Section 343 is new because it talks about the admissibility of sexual history evidence, and so therefore that goes back to the definition where they define the sexual history evidence as being part and parcel of the whole sexual activity. And again, we'll come back and talk about that in a minute. As far as Section 344 is concerned, it's quite substantially different to what appeared in the old Evidence Act. An application for leave under Section 342, that is to either cross-examine the complainant or adduce evidence from other witnesses in relation to the sexual history of the complainant, is split out into 4 specific sections. Section 344A is a new provision in relation to summary proceedings, and there is lots of matters at the lower end of the sexual offence matters, or matters that can be heard summarily. And if indeed any solicitor advocate runs the case or barrister there, the solicitor has to at least give the magistrate's court and the informant at least 7 days notice beforehand. Now, this is completely new. Up until this year, certain questioning was allowed, but often objected to, but there was no real provision that allowed for any notice requirements in summary proceedings. Now, the magistrate's court has Form A. Now, Form A is the form in which you use as a tick box in relation to the matters that you would need to attend to prior to any summary hearing or summary contested matters. It's called the Notice of Contested Hearing. And there now you'll find that the second half of that paper, you'll find a provision relating to Section 342. You would tick that box and then put in the annex to your form, your application for cross-examination or leave to adduce evidence in relation to sexual activity. And then, and this is something that you'd have to be aware of, you have to declare that you're ready for the hearing in summary matters, and that you would use Form B, but as of yet there is no tick box or some sort of notice to Section 342 on there. So you need to be very careful that when you're at least submitting that to the magistrate's court, that you take notice of Section 342 and any orders that you've wanted, because once that form goes in and you've said that you're ready, you may lose out on any cross-examination that may arise out of the hearing. Section 344B, this is similar to the old provisions, although the old provisions allowed a 14-day. This is now a 7-day notice period, so it gives you at least a little bit more time. But as well as giving notice to the DPP and the informant, you also need to file it at the magistrate's court. So you'll have to give 3 copies, and I would suggest that the copy that you file with the magistrate's court is filed with Form A. And then a similar copy is sent to the DPP and the informant. But you've got 7 days to do it, as was 14 days previously. Section 344C is largely the same. The only difference between that and the old provisions in the Evidence Act is you now need to file with the county court. Before, you only needed to send a copy to the DPP, but now you need to do it to the county court. The 14-day provision is the same, and there is an additional requirement. If a special hearing is to be heard, then it has to be at least 14 days before that hearing. So if a hearing has been issued in relation to any of these matters, then 14 days requirement has to be held. Section 344D is new. This didn't appear in the Old Evidence Act in relation to sentencing. A lot of sentencing hearings brought up the issue of the honest belief in consent and any mitigating factors. If anything arises from that in the plea, then you still have to have permission from the magistrate or the judge in order to raise any of these specific matters, and you have 7 days in which to do that. Then we get to the applications for leave out of time. So if none of the time stipulations in Section 344 have been observed, Section 345 and Section 347 deal with the application for leave out of time. Now, I've put that these are new, but see the old provisions, because curiously, the provision which was in the old Act stated no more exceptional circumstances. So that was a hurdle that we now no longer have to get over. The judge doesn't need to consider any exceptional circumstances, and that might benefit your clients. Section 345 and 47 just states if it's in the interest to do so. And I'll refer to some cases in a minute that discuss that in detail. But it means that any requirements for leave and any application to the court would only have to address the interests of justice to do so. It hasn't been judicially decided what that means, but curiously, no more exceptional circumstances is contained in either of those provisions. It might mean that the defendant would more often or not be granted on the balance of probabilities in their favour, but certainly the judges or magistrates no longer need to decide whether there's exceptional circumstances. Section 346 is largely the same as the old Rule 37A5 AA with the exception of subsection 3. And this is really in relation, not in relation to the cross-examination of the complainant, but the adducing of evidence other than the complainant that may give rise to the embarrassment or bias in the jury or anything contained in Section 349(a) and the things that the judges might have to decide and whether to grant leave or not. And those provisions are largely new. Then we get to Section 3. I will mention that Section 349 is a direct replication of the old 37A3A. There's no change there in relation to what the judge has to take into account and whether to grant leave or not. So that's a direct replication. Section 350, the determination of application for leave during a sentencing hearing, is new. Now, for people in the room, the most important part of the change here is that there is no requirement that the defendant needs to provide a guilty plea or at least an intention to do so at the committal stage. Prior to the new Criminal Procedure Act, the defendant had to at least give some sort of indication or a notice of intention to plead guilty at the committal stage for any determination under the old Section 37A3 subsection B. Everything else in Section 350 is the same in respect of the sentencing hearing, and so in other words, they can maintain their position right up until they've been found guilty at the county court, and still make application for leave to adduce any information in relation to mitigation of those particular circumstances. Section 352 is the limitation on sexual history evidence, and this is where it gets a little bit confusing. because of the definition in the earlier provision where they define what sexual history evidence is, and sexual history evidence is now regarded as part of any sexual activity between the two actors or players in the matter. And you know, I would draw your attention to that when preparing your application. Under Section 342, you have to at least outline under Section 346 the questions or evidence that you're wishing to adduce, why you are wishing to adduce them, and what evidence is likely to come from that, or questioning is likely to come from that. So in finishing, and this is probably the mainstay, is that the relevant case law in these provisions, and I've put them in, was R versus O'Neill. This was a case where it was a child of 16, or 11 or 12. She was 21 years at the time of the trial, and the judge refused leave because notice hadn't been given and that there were no exceptional circumstances. Now, in my view, the questioning might have been allowed, and I'll probably piggyback on Trevor's point on the interlocutory hearing. This might have been a part of an interlocutory application, because the judge refused oral leave as is required under Section 347. You can make oral application and waive the requirement of writing during the course of a trial. If it's refused, it may end up being an application under Section 295, subsection 3 of the Act. And I would probably say, well, not giving in all probability, but definitely the judge in that case, if it was heard today, wouldn't have to take any notice of exceptional circumstances, but whether the interest of justice required it, and the judge should maybe have allowed at first instance in the trial to adjust the evidence that was required or requested at the trial stage. The last one, R versus Vela. This was also a case where information was gleaned during the course of the trial. The complainant had been sexually assaulted, raped, but the day after she was raped, she'd met a previous sexual partner and just said that, you know, she'd been assaulted. And later on in the proceedings, she admitted to another sexual partner of long standing that it wasn't a sexual assault, it was a rape. And this was held in doctors' notes. Now, these doctors' notes hadn't been subpoenaed. Now, the question then becomes whether, if these doctors' notes had been subpoenaed in enough time to give the required notice of 7 days or 14 days as the case requires, whether the complainant could have been allowed to be cross-examined on these doctors' notes and what she said to the doctor. Then it became an oral application or a waiving of writing application during the course of the trial when it came to light. And again, given the 2 days' notice, if it's raised during the trial through no fault of their own, as Trevor has said, it then becomes an interlocutory appeal whether this complainant should have been allowed to be recalled and examined on these particular matters. Paragraph 11, they said that it would have to be of substantial relevance to any fact and issue in the trial. And again, this particular appeal said there were no special circumstances. So if we take out the special circumstances and just have the test of it's in the interests of justice that it be required, then again, that decision was 2008. It may well have been decided differently. But I think the lesson here is that, or one of the lessons is the leave requirement has been shortened from 14 days to 7 days. The narrative and instructions that you get from your client need to be quite important, because then you need to at least narrow the issues down when you're discussing with your client the sexual activity, that it does now link in with sexual history evidence, because the definition is quite clear. That's number one. Number two is when you're obtaining any other evidence from other witnesses, then that witness information becomes important, and that evidence would need to be required under the order of, in Form A prior to the committal. that you want to adduce evidence from another witness, be it a doctor or another witness that is maybe one of the actors in the whole circumstances. And then two, if you haven't or something has went by the wayside, like subpoenaing documents and trying to get some more information, then it does form part of an interlocutory appeal if indeed the oral application at court under Section 347 has not been granted. And that's really it. Quick, and always was meant to be quick. It's just that it was contained in the old Evidence Act and is no longer there. And but it appears curiously right in the middle of the Criminal Procedure Act, and hopefully that's been beneficial to you all.
Thank you, Rodney. Thank you very much, Rodney. Before I invite any questions, can I just touch upon a subject matter that is not in any paper that you have, but I thought you should be made aware of it. And that is that the Criminal Procedure Act does affect some major changes, I mean, I believe they're fairly major, to the issue of disclosure. Previously, under the Magistrates Court Act, in Schedule 5, for the purposes of committals, there was a list of what was to be contained within a hand-up brief. Similarly, within the Magistrates Court Act, there were provisions in relation to what was required to be provided by the prosecution or by the informant for a summary hearing. The Criminal Procedure Act now sets out in very detailed form in Section 41 in relation to summary hearings, in Section 110 in relation to committal proceedings, a large list of what is required to be included in the brief of evidence for a summary hearing and the hand-up brief for a committal hearing. And it's not only that what is to be included are the statements to be relied upon in the trial and the charge sheet and in terms of a committal, your client's prior criminal history, but significantly in relation to both summary hearings and committal hearings, to be included in the hand-up brief is any other information, document or thing in the possession of the prosecution that is relevant to the alleged offence, including a list of the persons, including experts who've made statements or given information relevant to the alleged offence. So in other words, if a person has provided information to a police officer, hasn't made a statement, but is relevant to the issues concerning the offence, there's a requirement that that information, be it in a statement form, be it in a written form, in notes from a police officer, are required to be included in the brief of evidence for a summary hearing and in the hand-up brief for a committal hearing. And not only does the Act affect a change in terms of what's to be included in the brief, there is now an ongoing duty of disclosure on a continuous basis imposed on informants and imposed on the prosecution generally, including the DPP. And that is to be found in terms of summary hearings in Section 42 of the Act, for committal hearings in Section 111, and for trials in Section 185. And that imposes an obligation on the prosecution to provide, once they become possessed, of any documents which otherwise will be required to be included in the brief. In other words, if the informant becomes possessed of some notes of a conversation that a police officer has had with a person relevant to the charge, or the DPP become possessed of matters such as that, intelligence information, conversations, they have a duty under the Act to disclose it, and if they don't disclose it, in terms of provision to an accused or their solicitor, they have to inform you of the fact that they don't intend to do it. They have to bring to your attention the existence of it and indicate that they're not prepared to provide it to you, presumably on an argument of public interest immunity. So the Act affects a change in relation to continuous disclosure. This is in addition to, and this is set out in Section 416 of the Act, the general obligations that the prosecutor has anyway in terms of general disclosure, the duty of general disclosure. So the Act affects specific disclosure obligations on a continuous nature, both on the informant and on the prosecution generally. And that would mean for you as solicitors, you are able to keep the pressure on by getting in touch with the informant, by getting in touch with the prosecution if it's been prosecuted out of the Office of Public Prosecutions and requiring them to disclose to you items that may have come into their possession by drawing to their attention their obligations under the Act. So it's an Act that covers a lot of change. It's an Act that also incorporates now in the one document, as I said at the beginning, what is now the rules for procedure in all criminal matters in all jurisdictions. In the remaining time, which is only 5 minutes, I'm told, do we have any questions? Well, thank you very much for coming along today. I hope you enjoyed the seminar, and good luck in working with this new legislation. Thank you.